Great. Well, thank you very much, everybody, for remaining awake. Because this is the last session before you get your drinks. This is always known as the graveyard slot. So I'm really grateful for those of you who wanted to stay and listen to this. What we planned here today is a slightly different topic than usual, perhaps, because this really, we're talking about a public policy issue. Where do class actions really sit in the larger framework of regulatory action, bringing people to book, remediation, and also, of course, what regulators do is issuing penalties for wrongful behavior. How do these things now sit together? Now, with me I have an ex-regulator who's probably sat on nearly, or chaired nearly all main regulators in the United Kingdom. David Currie was the chair of the Competition and Markets Authority. He was chair of the competition as a communications regulator, Ofcom. He's on the board of the energy regulator. He now chairs the Advertising Standards Authority. And he's a member of the House of Lords, so he has the opportunity to input to our parliamentary system as well. Tom Clark, you'll maybe have to read in his bio, comes from New Zealand. He qualified there, but he spent 7 years at Slaughter and May, working on important issues there, including on secondment to Rolls-Royce and Shell, so he's well qualified in the UK legal system, before joining which is the UK Consumers Association, and he's responsible for the strategic media litigation team responsible for developing which is legal actions that support its initiatives to protect consumers. Each one of us is leading a class action under the new regime that's been included in the UK. My own background for doing all of this, I was the financial ombudsman in the UK, and I've also been involved with remediation and involved with regulation, particularly the financial regulators. But I've also been involved with a number of other regulators. I worked for the Law Society for 10 years, so I know all about legal regulation. And I was on the board of the Gambling Commission, which is the gambling regulator. I've been involved in I chaired a press regulator, and I was on the advisory board for the Civil Aviation Authority looking at passenger issues. So I've seen lots of different regulators clambering around the space and interacting with attempts to remediate consumers. So that's our brief, is to say, well, do these regulators really benefit, or could they benefit, from the class action regimes that now are amongst us? Because class actions are now beginning to be one of the fastest growing areas of consumer litigation, or commercial litigation, whichever side you look at it, in the UK. So that's our brief. And what we are also going to challenge you, particularly those of you who are not from the UK, and we have a good international audience here, is to give us some of your reactions as to how far this resonates with you in other jurisdictions, because we're only really any good at talking about the UK. So I'm going to first start with David. David, you've been chair of regulators well before, of course, any class actions came into being. But before you do that, just tell us about your class action.
Well, thanks very much, Walter. My class action is against 4 crypto exchanges on behalf of nearly 250,000 UK holders of a particular coin, BSV, which was delisted by all these 4 exchanges, and in one case expropriated, in collusion. Together, they did it all simultaneously. And in most collusion is often very difficult to prove. In this case, we have a Twitter stream between the heads of the exchanges, which is pretty strong evidence that they were effectively combining to take this action. The damages that we're seeking are the upper end of the estimates, and of course they are estimates, something like 10 billion sterling. So it's a big action, and we're in the early stages. We have our hearing next June. These processes proceed very slowly, but we have, we think, a pretty strong case.
And roughly how big is the size of your class?
About nearly 250,000 UK holders only. There's potential for an action like this for holders elsewhere outside the UK to then pursue it.
They'll have to take care of themselves.
Yes. Yes.
Thanks, Walter. Thanks for the introduction. So I'm here representing Which, and I think because it is an international audience, worthwhile saying a little bit about who Which is. As Walter said, it's the UK's foremost consumer body. We have around or over 500,000 members, and we're very involved in trying to make sure that the UK's legal regulatory regime is one that works for consumers, and we'll come on to this hopefully in one of the things we're going to be talking about, because there's a very important piece of legislation currently before Parliament which is going to shift the dial quite heavily in terms of consumer law enforcement and in terms of digital markets enforcement. So we'll come back to that. Our claim is against the US chip manufacturer Qualcomm. So in a nutshell, the allegation is that Qualcomm, who supplies chips to mobile phones amongst others, and if you've got a mobile phone in this room, which I'm sure everyone has, you'll have a Qualcomm chip, no doubt, in that phone, and that through its licensing practices and its supply practices to OEMs Apple and Samsung, it leverages its dominance in the chip market and the market for standard essential patents to essentially extract super competitive royalties from Apple and Samsung, which are then passed on to consumers in the form of higher cost or lower quality phones. And so that's a class of around 29 million UK consumers who have bought a phone whether outright or on contract from the 1st of October 2015. So again, if you've bought a 4G phone and it's an Apple and Samsung phone, chances are you'll be included in our class. It's slightly smaller than your claim, David, at around 480 million, but I'm constantly reminded when we're talking about these sorts of claims, and it's relevant to the topic of enforcement, just how big they are. And we throw around these numbers, 10 billion, 480 million, Walter's, yours is even larger, like they're sort of pocket change, but they are enormous numbers and made up of often quite small claims that go into them. So that's our claim in terms of details. We were certified as a class representative, which of course is required in the UK's competition opt-out regime back in 2022, and we've now had sort of a number of case management conferences and sort of in the depths of disclosure, so very much into the claim.
My claim is against Mastercard, and I was effectively the first case to be certified, the first case to get underway under the new class action regime. It is a very large case. My class is something like, it's well over 40 million people in the UK, so it's effectively all adult consumers in the UK. And my case is about the multilateral interchange fees that Mastercard charge to retailers, and we say that retailers then simply pass those costs on to consumers in higher prices, however they bought things from retailers whether they paid by cash or card or check or any other means of payment. So that's why the class is so large. And estimates originally were somewhere around 16 billion pounds. It's probably a little bit less now. Mastercard has managed to chip away a little bit, but we've still got some way to go. We started our case, well, I started my case in 2016, so we've been going for 7 years, and we probably have some little way to go yet. Anyway, back to now the sort of, sorry, you want?
I was just going to say, is it worthwhile saying your claim is a follow-on claim with, but not entirely?
Correct. We distinguish between, well, we use these different terms. A follow-on claim is a claim that, as it says on the tin, if you like, follows from a regulatory decision. My case follows from a regulatory decision by the European Commission, which is a regulator of competition issues in Europe, and we were part of the European Union at that time, that found Mastercard effectively guilty of fixing its interchange fees together with the banks, and was told not to do that anymore, and that it had been breaching competition law. So that's
well, ours is a standalone.
Yours is a standalone claim, and so is David's, in the sense that no regulator has been involved. No regulator has. I'm not sure there is a regulator that could have been involved with yours, David, but
yes.
There probably could have been. But anyway, so we come back to this question now. How far do regulators, more generally, because we can, as class representatives, we are part of this network where we talk to our fellows who have been nominated to be and have been approved to be class representatives, which is a completely new and novel role in the UK administration of justice. We have to be approved judicially to take on these roles, and many of those who have taken them on have no particular experience in commercial litigation or in litigation funding, but have been appointed because they have either experiences in the consumer world or perhaps in the specialized area relating to the subject matter of their claim. So there are not many people who really have all the experience necessary to be a class representative, so we're all a little bit on our own, and one of the ideas of the Class Representatives Network is to bring us all together so that we can actually talk to each other rather than feeling totally alone in this world. So I want to talk to you now, David, about what it would have looked like as a regulator had class actions been involved at the time, and I think you were certainly around at the time when the new regime was being considered and thought about, but you perhaps weren't there quite enough to see it actually brought into being.
That's exactly right. When I was bringing together the CMA by merging the Office of Fair Trading and the Competition Commission, it was after that period that the new CAT regime for class actions was being conceived and developed. We were very careful not to be too overt in our support for it at the time, because of course the CAT is our appeals tribunal, and therefore a separation between the CMA and the CAT was important. But behind the scenes, we were certainly supportive. And let me just explain why. I mean, I was quite vociferous about the fact at the time that if you look at the resources available to the UK competition regulator then, it was 1/10 of the resources available to the economic sector regulators. The reason for that is very simple. The sector regulators are funded from their sector by a levy, whereas the competition regime is funded out of general taxation, and therefore the constraints are much greater. As a result of that, we had to prioritize what we did very, very carefully. And there were many cases, deserving cases, that we were simply unable to pursue. I mean, honestly, in part because each action we did take involved a huge amount of work, often successive appeals. I think of Ryanair and the cross-channel ferry cases where the huge amounts of appeals, a lot of resource had to go into it. And as a regulator, you have to get everything right. The other side only has to find one thing wrong in what you're doing, and the case fails. So you have to be very careful, very resource intensive. So you have to make very careful choices. And also, we have to prioritize on the basis of a number of criteria. It's important that we cover all sectors. It's clear that competition law should apply in every sector. So you deal with the big boys, but also with the estate agents and the car dealers. You've got to make sure you cover the whole of the United Kingdom. It's not just focused in one part of the United Kingdom, but you have actions that are relevant to Northern Ireland, Scotland, Wales, and the north of England. And that means you make a whole set of assessments based on those criteria and have to prioritize very carefully. The result is there are quite a lot of holes. There are quite a lot of things that are left to one side. And if one thinks in terms of pure financial loss, there are quite significant gaps. And therefore, our hope was that the private class regime actions would fill those gaps. Private money would come in, pursuing return, quite obviously, but on different criteria, with different risk factors at work than we were, as a regulator, were applying. And for that reason, it seemed to me that it seemed to us that this was a good regime. An important reason why it didn't apply more broadly than competition is that, of course, the CAT was in place as an institution to oversee this, not the case more broadly. And there had been arguments that the regime should extend more widely on breaches of consumer law. And that was rebutted by government for a while Richard Lloyd pursued his case against Google through the courts. But now it's failed in the Supreme Court. The argument for extending it more broadly beyond competition, I think, is a very strong one. But that's the background. And that's why, giving a regulator, I can't speak for the CMA now, but from my perspective then, that was the reason I was very supportive of this regime. I was therefore very enthusiastic when I was approached to take up a case.
Just to reassure those of you who may not be following all the cases that have been launched in the UK, Google is not entirely exempt from being attacked by class actions. A number of class actions have already been launched against Google in the UK, and I suspect there will be more to come. So if you act for Google, well, you probably know about them already. Tom.
Well, I thought it worth picking up the point about where the regulator stops and where private enforcement or private actions or class actions, however you want to define it, picks up. And I think it's important to identify that some of the objectives of regulatory enforcement will be different, or indeed they stop at some point, and there is a gap that class actions, private enforcement can fill. And specifically, I'm thinking about remediation. So how do you find and remediate to the best extent possible those who have been harmed by whatever the infringement is that has occurred? And you'll find that most, certainly within the UK, regulators, either they don't have the power or it's not really on their agenda to be trying to do that remediation side. It's very much about, trying to uphold the law. So, you find the infringement, you go after it, you stop it happening, there's a fine, there's a sanction, there's deterrence as a result of that. But what about the people, the businesses who have been harmed as a result? And that's, I think, for us particularly, as a consumers association, why we are so positive about the competition collective action regime, because that's exactly what it enables. It enables the grouping together, as everyone in this room will know. smaller claims that wouldn't otherwise be brought into a larger claim that then becomes viable to bring as a collective action and provide, an avenue to redress for, millions of consumers or, large numbers of small businesses who might otherwise not bring the claim. So I think that remediation point is a really important one, and that's where private actions can do a huge amount of good. Although we are still, at least on the collective, the opt-out collective regime, we're still waiting to get there. And so, it's not perfect yet, but we're learning as we're going, and it's certainly a positive that it exists, and hopefully will be the sort of vanguard to a greater expansion in the future, particularly to say, because it is only a narrow regime at the moment.
Well, now, one of the things that it's often pointed out about the UK class action regime, and I'm particularly aware of it, is, and some of you in the room will be, particularly if you are from funders or know the funding market, because all these cases have to be funded right from the start, and funders have to be rewarded because they're not going to put their money up and invest in a possible class action unless they can see that there's likely to be a substantial reward for the risk they take. After all, the case may look satisfactory and likely to win they have a nice legal opinion saying, yes, it's a surefire case, it's going to win, or it'll win quite a bit. Is it going to win enough? And is it going to be enough of a payout for the regulator, for the funder, to receive the amount that it feels that would reasonably reward them for the possibility of for the risk they're going to take, investing the money, for being parted with their money for potentially a long time. As I said, my class action's now gone on for 7 years, and my funder is not surprisingly, well, I would say getting itchy. Of course they are. But anyway, they're going to have to hang on for a while until we reach a conclusion. But when looking at a case that is potentially fundable, any funder is going to say, well, under this regime, I only get paid if the class members don't come forward in sufficient numbers to claim all the money that is potentially available to them. There needs to be an amount of unclaimed monies available to be left over at the end after the class members have all had their chance to come forward and claim the redress they're entitled to. Isn't that a big gap in this whole regime?
It's a peculiarity of design, and I think there is a question why it wasn't provided for in the regime, that the funders should get a reasonable return, obviously overseen by the CAT, rather than relying on the residual left over. And so one of a couple of members of my advisory board on our claim are very critical of the UK regime in this respect, that it would be better, it could be better designed. But it's what it is. We work with what we have.
So, Tom, you said this is a wonderful regime. Of course, in many ways it is. But is this a serious gap? Is this something, a flaw in the design? How else could you incentivize private money? You both talked about the importance of bringing private money into the regime to support regulators who have limited budgets, particularly regulators that are funded by the taxpayer, who are never going to get as much as they would really ought to have. So do we think this is a serious gap or just a temporary criticism that will be remedied as far as we go along.
We're talking in the abstract at the moment because we've not had a collective settlement or an award of damages, at least in the competition opt-out regime. Of course, we do have, and there has been talk about this today, other means of bringing group actions in the UK which are funded, and they seem to be getting along fine in terms of funders being prepared to fund those on commercial terms, and the claimants in those actions being prepared to take those terms and to take those claims to trial, or at least to settlement. I get the difference, obviously, is the size of an opt-out collective action, which I think is also at the same time the benefit that means we probably have more flexibility in how much there is likely to be to ensure that you're able to do, one, right by the class members and have sufficient amounts there for them to claim against, and two, ensure that there is a return for, not just the funder, of course, but you also have law firms, who are often putting up at least, or acting on deferred fee arrangements to be involved in these cases. So, I do think there's enough scope for this to work out. I would also, I guess, put the question back, what would be the alternative? Because to have a more, I guess, tighter regulatory regime that use something like reasonable returns or set some sort of return figure, is that going to provide the flexibility that we need to bring different types of cases? And I think that's another kind of hobby horse of mine is we've talked about, I mentioned at the start, the size of the claims that we're bringing. I mean, they are because you don't get funding for small claims because they're not commercially viable. So we have to make sure that there is incentive for the commercial parties who are supporting these claims, the funders, and of course you've got insurers as well, to get a return that incentivizes their involvement. Otherwise, these claims won't be brought, and our discussion about whether class actions can support regulatory enforcement will be a very short one because the answer will be no.
So, David, now the other feature, as it were, of the regimes that we have is that the class actions and class action regimes, even though they may be firmly within the purview of one of the regulators, and there's a claim operating within that territory, there is no connection. The regulator just sort of presumably stands by and watches it, and wonders whether, well, I don't know what they wonder. They just do you think regulators are going to be really cheering things on behind the scenes, or are they just going to say, well, that's in another world? It has nothing to do with us.
I think, for the reasons I said, that the regulators have to make choices about the cases they take. They may be happy to see follow-on action subsequently, because if they result in significant damages, which they may or may not, if they do, that increases deterrence effects, and we can discuss that question. But in the areas where they decide they cannot act, for example, the CMA could have taken my case. I think it's inconceivable that they would have done so. I would certainly not have backed it.
But do you think there should be a connection? Do you think should have meant the CMA should be formally notified of your case, and that they should be allowed to make observations?
I think the fact that all the notification goes through the CAT connects it into the competition regime quite effectively. I don't see there's any need for anything further.
Okay. Well, the other criticism that's made of class actions is that they really are just a vehicle, playthings for funders and lawyers. Mastercard for instance, is not short of telling the world that my case has nothing to do with remediating of consumers. No consumers have complained, and this is all about about making money for funders and for lawyers. And this is nothing, therefore, they would also carry on to say, this is nothing to do with regulators. We settled, we had our interaction with the regulator a long time ago. This is all over. And what's happening now is some invention that has nothing to do with benefiting consumers at all. Are they wrong?
I thought we had put this question to bed, Walter. In that I feel like it's been discussed at such length, and it's the argument that gets rolled out so often. And then again, I think you've just posed the question back, well, what's the alternative? That particularly where you have a follow-on action, but in cases where you have a business, an undertaking that has either admitted to or essentially been found to have infringed, there is likely to be, although not always, but likely to be some group that has suffered as a result. And to then say, well, you don't have an option to seek redress for that loss feels to me like an injustice. So that, I think, is just the basic response to that point.
I would agree with that, but the regime is still nascent, and we haven't seen any significant settlements or payouts. And until we do that, until we start to see significant payments, then I think we have to leave, the jury is still out. And it's only when companies find they're being hit on the bottom line that they will start to pay significant attention to the regime.
Can I just talk to that? So I think it really demonstrates, though, or it's important for us as stakeholders, practitioners, people involved in the industry about why it's so important how we act, and when we have the power to influence how these outcomes, or what these outcomes are going to be, that we are doing our utmost to make sure they are ones that are positive and beneficial for the regime,
yes.
And make it something that people can trust and rely on, and that essentially then also is then a rationale for greater expansion into the future, which of course is something that, as I said, we are very keen on.
But the point that actually lawyers get a significant return from all of this is absolutely right. My first case hearing had 4 separate legal teams for the 4 defendants on the other side. And it reminded me a bit of the Leveson inquiry in which I was an advisor, and I wanted to put a clock up at the front of the court which had a dial which went round reflecting how fast the fees were accumulating in the case. I mean, it is very expensive. Competition cases are very expensive.
So let's think whether these cases do really act as deterrents. The commentary from the courts has been to suggest that one of the purposes of the regime is not just to remediate those who've lost money, but it is to pass on a message to businesses, corporations, that if they're tempted to engage in anti-competitive behavior, the damage that they will have done may be capable of being extracted from them and passed back to consumers. That is what some of the judges have said. Now, is that realistic? Do we really think that the bosses of the boards of directors of major corporations are standing thinking, oh dear, if we have a dominant position in this market and we haven't really made sure that consumers benefit from the position we're in, that we may face some class action. Well, do we really think that this is actually going to be a motivator in the minds of senior executives and those who are defending the interests of shareholders of these companies? I just am wondering whether this is just pie in the sky.
Do you want to start with your view, Walter?
Yes.
Because
Sorry,
then maybe
I'm the chair of this thing. I can throw things. Okay.
Well, I can start with my view if you want, and then you can build on that.
Okay.
Should I do, well, I'm a bit cynical about the deterrent factor. I certainly would hope that that is where we might get to, but at least at this point, and particularly, as you've said, David, with a nascent regime, I'm not sure whether this is really swaying decisions at the board level, the decision maker level, particularly if you're talking about large multinational organisations who might look at the size of some of the claims as more of a rounding error on their bottom line. That's not to say, of course, particularly your two claims are very large. That might be different for claims that are perhaps more, or the business is more UK-centric, so there's more of a reputational issue. For smaller businesses, that it would actually massive or majorly impact their bottom line, as well as I think for perhaps products and services that are much more consumer-focused. So ones where they're much more forefront of mind for the people who are consuming them, the businesses who are consuming them, and that where if they understand that the supplier of that, the manufacturer of that, has committed an infringement, that actually might have also other significant impacts on them as a business. But I think the jury's still out for me on whether there's that deterrent effect. But I would still say I think remediation is sufficient as a rationale.
Okay, I mean, you wanted me to put my head on the block as well. I agree with you. I am a bit cynical about this. But I will distinguish between cases where the events complained about are all over, or they're part of a continuing business model for the organizations concerned. I think my case is about activity that Mastercard engaged in 20 years ago or more, and it's all over. I don't have any dispute with Mastercard now because, maybe they are up to no good, who knows, but it's not my case. That's all over. There are other cases that have been launched, to a certain extent yours, and obviously, well, yours is your regime, your defendants collapsed these exchanges, so that's all over, and you're looking at the outcome, as it were, the result of all that. But I think there are the cases where the attack is on the business model of that is currently in play. That is a serious attack on the way those companies are making their money, and to undermine that through a class action, I think could be quite considerably effective.
I mean, just two points. I think if our claim is successful, it will emphasize to crypto exchanges that they are subject to national laws, whereas currently many of the people who run these exchanges do not think they are subject to the law anywhere. And secondly, I mean, you take the legislation, take the litigation that's come from out of the phone hacking thing. A lot of litigation. You say, would that have any effect on decision making? Well, I think the $750 million that have been paid out by News Corp probably have meant that the media companies have changed their ways, and they might not have done so. So I think it all depends on what the bottom, how much payoff you actually get. And in the end, the regime is still to be proven.
Okay. Well, I think we've given this a good run, but I do want to, I've noticed that when the invitation has reached this sort of point in many of the other sessions we've been at today, the chairs have failed to elicit any substantial comment or questions from those of you here. And I'm really pleased to see we've got one question coming up from Natasha Perman, I think, and she's going to be provided with a microphone.
Thank you. There it is. Yeah, I was just really interested in some of the comments on businesses thinking about how the cases impact on board decisions. And I was looking at dawn raids, and obviously dawn raids are usually instigated via leniency applications. And I'm going somewhere with this, it might sound a bit random. I think the stats around that show of the European Commission investigations up to about 2018, 25 of those were 28 dawn raids that took place between over a 7-year period were instigated by leniency applications. So there's been quite a significant drop-off lately of leniency applications, and I wondered whether that was in part because of the follow-on regime and how maybe there might be consequences falling out of the follow-on regime that weren't really thought about, or so are we going to see cartel damages actions when there's no leniency applications, I think is what I'm getting to. And where does that leave our UK regime? We've got a lot of standalone actions that are based on abusive dominance, but we're not really, for obvious reasons, seeing anything in the cartel space. So wondered if the panel had any thoughts on that.
Interesting points. Can anybody from overseas help us? What do these sorts of debates really resonate in the US, Canada, elsewhere elsewhere in Europe? Or does sorry, we have got a hand up there. Thank you very much. Would you like to tell us who you are?
Yeah, hi. I'm Dan Gerard. I'm a lawyer from San Francisco and have practiced as an advocate for claimants for almost 38 years now. The issue of deterrence has been studied quite a bit, and despite all that study, I would say there's still not a consensus in the United States. If you talk to the corporate side, they'll say that they're burdened with class actions and that there's a continuing problem with costs of discovery and the risks created by class certification. That's a decision or a perspective that the Supreme Court, under its current makeup, has largely adopted. Most of the academic studies suggest massive underdeterrence, and that while there is a significant volume of class action litigation, it is inadequate to address a lot of core issues. My own observation, I sat on the commission that is charged with the reform of the procedural rules, including the class action rule in the United States for 6 years, is that the desire to achieve ever greater procedural accuracy is in tension in a lot of ways with the objective of deterrence, because it tends to complicate class actions and slow them down, along with another important trend that's happening that was touched on in the context of the discussion of settlements, where courts have been very focused on increasing the payout to individual members of the classes, as they should. At the same time, raising the bar for settlement approval tends to play in the direction of underdeterrence, because it makes some types of cases harder to bring. So this is very much an active, ongoing debate in the United States, and I think how you answer the question really depends on the perspective that you're taking and is worthy of additional research, because it's really at the core of what we all do, and it's very much what we should be concerned about. Thank you for entertaining that long-winded response.
Well, thank you very much indeed for that, both those contributions. Our time is now up. Your time for a possible drinks reception. Andrew is probably going to just remind us of who's sponsoring that, and